All rise. Please be seated. Welcome to the final rounds of the 10th edition of the All Kenyan Moot Court competition on this 25th day of March 2022 at Kenyatta University School of Law, Parklands campus. The court is now in session.
This is Presidential Petition 1 of 2022 in the matter concerning the alleged violation of the constitutional right to a free, fair, and regular election based on universal suffrage between Kutesa Human Rights Commission as the first petitioner versus the Electoral Board Commission and 6 others. The Honorable Chief Justice Ochiel is now presiding.
Good morning, Council, and welcome to the Supreme Court. We'll hear first the petitioner, but before that, I'll allow my colleagues in the room just to mention
Welcome. Good morning, everyone. My name is Wycliffe Oyo. Pleasure.
the petitioner. You have 30 minutes.
Thank you, my lord. I must say that I'm glad to be here before this Supreme Court in a matter of human rights violations. And with the latitude of the court, I'd like to begin my submissions. Before the law is a human rights association seeking and asking this court to assert the supremacy of the Constitution and the sovereignty of the people. My lord and lady, it is expedient that the first thing we state is that a country's fidelity to its constitution, as well as its adherence to the rule of law, is its greatest promise for a greater tomorrow to its people. That being said, and with the guidance of this court, my name is Shamia Muchesia, lead counsel appearing on the behalf of the petitioners, Kutesa Human Rights, and together with me is my co-counsel, Cherry McKenna, and together we shall use, out of the 30 minutes allocated, we shall use 14 minutes each and cede 2 for rebuttals. During my 14 minutes, I shall be able to take this court through the issues of jurisdiction, admissibility, and locus standi before moving on to assert that indeed there were principles that were violated in the elections held on the 6th of August in the Republic of Mbwaki. If this court will permit, I'd like to move on to the issue of jurisdiction. We assert that indeed this court does have the jurisdiction to hear issues B and C and D all together, my lord. The only contestation as to jurisdiction is not with issue B, because you will realize that issue B is one which asks this court on the presidential question, which is under Article 163, clause 3, subclause A of the Constitution of Mbwaki, as read with Article 140, clause 1 of the Constitution of Mbwaki. And therefore, the only conundrum and the only contestation as to which the respondents may claim in this instance is that to which of human rights violations. And to that, we ask this court to to humbly adjudicate on those matters as they are within the jurisdiction of this court. Now, my lord, our first foundational submission is that these rights occurred incidentally. These rights which are being alluded to in issues C and D occurred incidentally to the happenings of the presidential elections. And therefore, my lords and ladies, make no mistake, they cannot be separated from the happenings of the presidential elections.
And so the election is a process, we all agree with that. But the seats that occurred after the election, why should we not go to the High Court and why should we hear it now?
My lord, the issue as to, with regards to issue C, that was intimidation on the part of the government, because as we are going to present, it was related to the declaration of the presidential results. It was a means of intimidation. And on top of that, they needed to have followed a specific procedure to get us to where they needed to be. And therefore, my lord, we cannot separate these issues from the presidential elections in its entirety. For example,
the issue here, Francis,
yes, my lord.
Yes. Intimidation could have been, but it came after
the declaration of results. So it could not affect any voter. So how, just persuade us on that bit.
Thank you. The nexus in this issue is that, as stated in R versus IEBC ex parte code, the importance of the elections transparency is to be able to guide the people to maintain the perception of fairness. Now, my lords and ladies, make no mistake, if the perception of fairness within the election is not there, it attributes to these things such as violence and intimidation from the government in this instance. And that is what we submit as the nexus in this particular issue. And in another instance, we speak to the issue of Baby Amani, who was killed in this instance, my lord. That also occurred as a result of violence due to failure of the perception of fairness in these elections. And my lord, make no mistake that had there been the transparency and accountability, then Baby Amani will be sleeping on his mother's back and not on the arms of the angels. And therefore, it is our submission that we cannot separate these rights that were violated from the elections, which leads me to my principle, the principle I lead this court to, the principle of incidental concurrent jurisdiction, which allows courts to deal with matters incidental, collateral, and ancillary to the facts of which the jurisdiction states.
Actually, you have what is the understanding of incidental?
Thank you, my lord.
I'm not saying that. What is incidental?
My lord, let me give you a hypothetical situation. However, I'm going to back it with case law. For instance, if there is one dispute brought before the High Court, which entails environmental issues, which needs to go to the environmental and labor courts, as well as employment and labor relation issues, my lord, you need to realize that those are two separate matters that need to be dealt with two separate courts. And therefore, to avoid time wastage, we can take this issue to one court and allow it to deal with the matters of that other court, which happened incidentally or collaterally to the facts in that instance. Because we might have a situation where we're having time wastage because the suits are taken in different forums and whatnot. And also issues such as this and independence, where we have the collusiveness of the collusive nature of those suits. And therefore, it is our submission that if a matter happened in this instance, however, we have the jurisdiction to hear it, we should also hear other matters which occurred within that spectrum. And that is our submission on how incidental looks like. And this was pinpointed in the case of Henry Keegan and 6 others versus Baringo County Governor in paragraph 2. Where the court quoted the Court of Appeal case of Chimweli, Jangaa, Mangale, and 3 others versus Hamisi, Mwanawasa. And make no mistake, bench, it reinforced 2 major principles. And the first one is that the High Court is not the only court with exclusive jurisdiction to hear human rights violations. And secondly, that this principle of incidental concurrent jurisdiction is alive and breathing, my lords. This was reiterated in paragraph 31 of the case of Ketawa versus Kenya Power Limited Company. And the High Court, quoting the United States International University versus the Attorney General in 2012, it dealt with the issues incidental to that of its jurisdiction.
In those decisions that you have quoted, was there an issue of elections in them? Was there an issue of elections?
No, my lord. However, it is our submission.
You know, we are before the Supreme Court.
Yes, my lord.
You know, its mandate and jurisdiction on elections, presidential elections. So in those decisions that you've quoted, do we have an issue of election petitions so that you can tie it to the matter before us?
Thank you, my lord. Our submission is that there is no issue to do with elections. However, it establishes the important principle of incidental concurrent jurisdiction, where a court with that specific nature of jurisdiction is allowed to deal with matters to avoid issues such as we have mentioned, time wastage, expediency, and least and independence.
Counsel, as you have about 8 minutes left, you had told us you'd tell us why your client, the Human Rights Commission, are standing before us. It was not a party to the election, was it?
Yes, my lord.
Yeah. Why should we hear your client at all?
My lord, thank you for that question. Locus standi is granted to us under Article 140, Clause 1 of the Constitution of Mwaki, where it states expressly a person.
A person?
A person, my lord.
Your client?
Yes, my lord.
Is not a person.
Thank you for that question. Article 260 then guides us on who a person is. And in this instance, it is our submission that under that article, our client is an incorporated association as by the guidelines of Article 260 of the Constitution of Mwaki. And therefore, they do fit the criteria of a person in this instance. And therefore, my lord, it is our submission that the petitioners have the requisite locus standi. Moving on to issues admissibility.
Counsel, before you move on,
yes,
just for clarity, when you talk about incidental concurrent jurisdiction, please let us understand how far back or after a presidential election can this court inquire into the conduct of that election. And putting this into context in this matter, the petition is filed after swearing in. Issues C and D partly or wholly arise after the swearing in. So how far back can we go to determine that these issues are incidental to this election or are related to this election so that this court can seize jurisdiction?
Thank you, my lord. We are submitting the end is after there has been a hearing or no hearing in this Supreme Court. And that can only be when we say that an election has indeed ended. And therefore, my lord, we submit in this instance that this petition was filed after all those things had happened. And therefore, that is when, after this court conclusively deal with matter, when we can now say we have dealt with the issue of election. Submit that the issues are still happening, are still admissible in this court, and therefore they're incidental to the hearing of the presidential petition. My lord, allow me to actually guide you to the case of Kaba versus the Minister of South Africa, where, my lord, make no mistake, they adopted this principle of incidental concurrent jurisdiction, and therefore it shows a similar trend that these matters are not hearing those matters. My lord, that being said, I'd like to move on to the issues of admissibility. We submit that, in fact, these issues before the court are academic and not moot in any instance, and have not been filed anywhere, therefore not leading to an instance of police suits. And this is as the definition is given in Jessica Mao and 25 others. 10. My lords, our only prayer with regards to the preliminary issues is that this court takes a firm stand a firm stand and does not shy away from dealing with the jurisdiction it has in their hands. And therefore, jurisdiction, admissibility, and locus standi in this court should keep an active check.
The respondents tell us that we should allow the High Court to hear some of these violations, C and D, first. Then they can come up to us eventually on appeal. We are exercising our original jurisdiction.
Yes, my lord.
We have 14 days to hear you. Why should we load on these issues when they can go to the High Court and they'll eventually get to us?
My lord, the only problem with the High Court is that if we remit this matter to the High Court, they will need to go through the conduct of the presidential election. Remember that that is one of exclusive jurisdiction to the Supreme Court. And therefore, by going through the conduct of the presidential elections, they have to usurp the jurisdiction of this court. And therefore, this court is in the best interest of human rights to hear these matters, my lord.
Is there any harm that we find some of the issues and we proceed on the issue of the presidential election?
Yes, my
Is
lord.
there any harm?
As a matter of expediency and time saving, because my lord, these are people who have been wronged by the state, who are supposed to protect them. And therefore, it is our submission that as a matter of expediency, the state needs to compensate, or rather give remedies where they have wronged as soon as possible. And this court, as we know it, is one that does exactly that.
When you speak of as soon as possible, what exactly do you mean? Is there a time frame that's set out in written law or any internationally applicable standard?
Thank you, my lady. The only time limit we are aware of is that of the issue of Article 143, where this 140 clause 3, where this suit is supposed to be had within 14 days. And we submit that that is in fact the time we require this court to be able to give expeditious hearing. And therefore, my lord, seeing that I am remaining with 2 minutes, I'd love to move into the issues of electoral principles. Now, my lord, make no mistake that the Nawo courts assured the people of Mwakni, and they told the government that if in the event they choose to carry out an election, they must meet the guidelines of balancing between the Wuhan 19 pandemic and a free and fair elections. It is our submission that there were 3 principles which were violated as a result of this. The first principle is that of transparency and accountability, which we are going to conclusively try and deal with in the electoral system. The second one is that of universal suffrage, where we submit that marginalized communities were not able to have this opportunity. And even again, my lord, voting was moved from gazetted areas to non-gazetted areas, leading to a 10% impact on the people who voted. And lastly, my lord, we are going to submit on freedom from intimidation, where we can see that persons with disabilities and the elderly were indeed intimidated in these elections. Let's talk about transparency, my lord. Seeing that I have 30 seconds, I would like to ask this court for 2 minutes to wind up my argument. Thank you, my lord. On transparency and accountability, we submit that there was none of that. And why is transparency important for the people of Mwakni? Paragraph 6, we are told that there was tension in 2007. Matters so close to our heart, my lords and ladies. 2007, there was tension, and therefore transparency is key. And as I have referred this court to R versus IEBC ex parte code, the transparency maintains the perception of fairness. Once we have fairness, there is no violence. My lord, how was this then breached? It is trite law that signing of Form 34, signing of the Form 34s should be done by party officials. But this, we can attest, was not done, because in paragraph 30, we are told there were no officials in those rooms, and therefore the tallying cannot be credited in this instance. Secondly, we submit that transmission of results was also a problem, because if you move with me into the earlier facts, we are told that there are marginalized areas, especially in paragraph 18, marginalized areas that did not access network signals, and therefore the transmission therefore becomes a problem. The online publication of results, my lord, there was none of this, because the URL blocked the sites, and therefore the people could not verify. Paragraph 31, that is, and therefore we reduce this to a single.
The 10% of voters who couldn't vote, even if you give them, they lose it.
Yep. Thank you. To follow in the precedent of the Ukraine court, which nullified an election. Now, in the Ukraine court, my lords, we submit that in that instance, 77,000 of votes out of 6 million was able to cause the courts to call for a rerun of the election. And therefore, we are asking this court that where rights have been violated, take up active tools and assert the supremacy of the Constitution and indeed the sovereignty of the people. And therefore, my Lord, to conclude my argument, we state that the impact of the lack of transparency was that we see there were votes which were being transmitted out of nowhere. The incumbent was able to gain over half of the votes in 3 seconds. My Lord, there is no court in the world that will see this as a half of the votes in 3 seconds. This is password character. And therefore, my Lord, I'd like to submit that this was in fact an election that lacked transparency and accountability.
Thank you very much.
Thank you, my lords. And I'd like to ask this court that where there are irregularities, it should not fail to see this and to enact the human rights of the people, my lord. If I have no further assistance, I'd like to see to co-counsel. Thank you.
Human rights are not something that the government gives to you as a privilege. It is something that is entitled to each and every human being by virtue of them being free. Honorable Chief Justice, my lords and ladies, and as earlier introduced, my name is Cherry McKenna, and I will be submitting on behalf of the petitioners, Kutesa Human Rights Commission. I intend to take 14 minutes of this honorable court's time, and I will now proceed to my argument. My lord, it is our submission under issue C that the state did violate Mbogi Media's services freedom of media. Like I earlier said, these freedoms are not something that the state can just take away with no grounds. In demonstrating this, we will use the Syracuse principles as provided for in the ICCPR, which the state of Mbakni is bound to, as can be seen in paragraph 4 of the fact sheet.
These rights, counsel, are they absolute?
My lord, thank you for your question. This freedom of media right is not absolute, as can be seen in Article 34 of the Constitution of Mbakni. However, it can only be limited under grounds provided for in Article 33, Clause 2 of the Constitution of Mbakni. These grounds do not include treason, and those are the grounds that the state used to limit this particular rights. Therefore, it is not justifiable. In fact, in this particular matter, I'd like to refer you to the persuasive Attorney General and two others, where Honorable Justice Matibu expressly stated that this list, therefore, nothing can be added or introduced to this list. The law is the law. If treason is not amongst that, is not in that list, then it is not in that list, and we cannot use that as a ground to limit this particular right.
It's proportional, though.
We'd like to disagree with respect that it was not proportional. Seeing that the state in paragraph 37 shuts down all of the media services when only one news station under the media services was the one that recorded this. And even shutting down, even if they did shut down only this one, it would still not be proportional because it was not legitimate to shut it down in the first place.
Are we bound by Matibu's position? Sit down and explain.
But the Constitution itself, if we do decide not to refer to this particular itself, lays out this particular limitations and the grounds in Article 33.2, they are laid out in a conclusive manner. Therefore, the way they are phrased in that particular article is that they cannot be they are complete as they are, and that no new rules can be introduced to this particular.
Counsel, before you move on, about the question of legitimacy of the actions of the government in this case, what is your position about the purported swearing in that took place and the numbers that attended that purported swearing in? And don't you think that it serves a legitimate purpose to the rest of the country not to air such an illegal activity that is happening and therefore it is a legitimate purpose that the government is trying to achieve by shutting down the media after giving a warning that such actions should not proceed. What is your take on that?
My Lord, thank you for your question, and I would like to respond to that question by beginning to refer you to a case that this same Supreme Court decided in the year 2021. And this was the Communications and 5 others versus Royal Media Services and 5 others, in which it was seen that in paragraph 394, that by when freedom of expression is put to use by the media companies, it acquires a new dimension and becomes freedom of information. Therefore, this particular purpose of the state in limiting this particular treasonous act, if they did intentionally want to limit this treasonous act, then the fight is not with Mbogi Media Services, it is with Omonitimon and not Mbogi Media Services. It is our submission that by simply adding this particular inauguration ceremony, which we can see as per Section 35 of the Media Act, is legitimate for Mbogi Media Services to do, seeing that they are to air matters of public interest to the citizens and aid them in exercising their freedom of information. They rightfully did so as Mbogi Media Services. My Lord, if you will allow me to proceed in showing you how this particular act is not legitimate, as you have already helped me in demonstrating Article 33, the grounds laid down in Article 33, Clause 2 were not met. The grounds laid for in Article 24(1) of the Constitution of Working, where it is supposed to be proportional to the act, was also not met. And furthermore, this is not even the place of the state to be doing this particular limitation. Article 34, Clause 2.
What are the alternatives? Because proportionality means the other alternatives. What the authority have done?
My Lord, it is our submission that there were no less restrictive measures, because we understand that by conceding that there were restrictive measures, then that would mean that Mbogi Media Services did violate this particular right in this instance. The less restrictive measures they could have taken was simply not interfering with this right at all and dealing with Omonitimon directly, since Mbogi Media Services was simply just broadcasting this particular ceremony. Therefore, they did not take up a treasonous act by simply broadcasting this particular ceremony. If I may continue, in Article 34, Clause 2A, further to show you that this was not a legitimate act by the state, we see that Article 34, 2A provides that the state shall not interfere or control or exercise any authority in regards to what media companies can broadcast. In this particular instance, we see them interfering and exercising control and even going ahead to shut down Mbogi Media Services without proper conduct and without taking proper reasonable, as we see the purpose was not even fulfilled. Article 34, 2 Clause B also provides that they are not supposed to penalize any particular persons for what they did in relation to their broadcast. And we can see the government doing that again, contrary to what is provided for in the law. In paragraph 37, when they allegedly order through the Ministry of Information letters for the journalists who had taken part in this particular incident to be sacked, when it is not even in their place to interfere with media matters.
Are you saying that the state has no capacity to shut down the media broadcasting companies if, for example, they are spreading rumors or any other issues which perhaps might injure or rather might be a threat to the security of the state? Are you saying that the state does not have that capacity?
No, my Lord. We acknowledge that indeed the state may interfere to the extent where, as outlined in the Kituo Sheria versus and 33 others versus the Attorney General, it was outlined that the freedoms can be limited by the state in the regard where they want to protect national security. In this particular instance, this cannot be directly attributed to Mbogi Media Services, seeing that Mbogi Media Services was not directly linked. In fact, in paragraph 34, as the respondents may argue, you cannot say that this particular riot that came after this particular broadcasting was directly linked to the states, to the media services airing this particular information.
Council, allow me to interrupt you.
Yes, Madam.
So are you saying, in fact, that a media company does not have a duty to the state, or to the people, to the citizens, regarding the kind of content that they have? They have no duty whatsoever. As long as they're not involved in the organizing and the planning, they can basically hear whatever they want.
That is not our submission. The media does have a duty, and as previously stated, this particular matter is that of public interest. Therefore, by them simply broadcasting this particular matter, they were not contradicting any duty that they had, since they were just simply helping the citizens to exercise their freedom of information while also practicing their freedom of media. And as we can see, also if I may refer you again to paragraph 34, this particular incitement, this particular violent acts that happened in paragraph 34, which is a very important thing to note, is that they were not directly attributed to the media, because they say the situation arose as a result later on, but we can also see that the politicians involved propagated further war between the citizens, and that is what actually led to the looting and the harassment and everything. Therefore, it is our submission that the respondents should not use that as a ground to crucify the media services for simply practicing their freedom of media.
And the unfortunate events that happened to Mwaminifu, how can we attribute it to the state? It isn't known what happened to him. He was just found dead.
My Lord, allow me to address that one second issue, which I would like to briefly conclude on.
Issue. So when you talk about the limitation of the freedom of the media and the freedom of expression, we also see that actions were taken against Ndovuku,
Yes, my Lord.
who is the incumbent in this case. And there were actions also taken against the media station. Don't you think there is a balancing of rights here if we go by the pattern that Ndovuku is actually a respondent in this case? Is there a sense of the government trying to balance out those in power and those in the media and those in the opposition, of those who are running against the incumbent, so that we cannot come back and say that the government was discriminatory in the way it tried to enforce the law? What would be your comment on that?
My Lord, if I understand you correctly, then it is our submission that Ndovuku's freedom of expression was also not justifiably limited by the state. We see that the grounds they used as per paragraph 24 of the fact sheet were in relation to that he abused, that he used his freedom of expression to cause hate speech, advocacy of hatred, and unifying of others. However, it is our submission as put as a Human Rights Commission that this particular freedom was not violated, seeing that we have to ask ourselves very fundamental questions. What amounts to hate speech? Section 13(1) of the National Cohesion and Integration Act defines hate speech as any abusive, threatening, and insulting words that is intended to cause ethnic hatred. Whatever Ndovuku says in paragraph 24, none of that can be directly linked to cause ethnic hatred in this particular instance. Therefore, it does not amount to hate speech. Otherwise, every Tom, Dick, and Harry will be using this particular ground. If you have insulted me, then you have used hate speech against me. So therefore, this particular right was also not violated. Was violated with the state. Allow me to now that I have shown you that it was also illegitimate and not necessary, seeing that the purpose was not met and also not proportional, it is our submission that this particular right of media was not justifiably limited by the state. Allow me to now move into issue B, in which I would like to address my Lord's question on Mr. Mwaminifu's death. And we can see that in this particular matter, it is not justifiable by the state, considering that the circumstances in which he died was also not, it is not justifiable generally. However, we cannot, we also agree that until the investigations by the Director of Criminal Investigations are done, we cannot attribute this to enforced disappearance, considering that this particular person involved is unidentified.
Counsel, of guiding this particular court and specifically the bench, what entails enforced disappearance? Because you say that it can't be enforced disappearance, yet Mwaminifu was known as Mwaminifu, and in your statement you bring out the fact that he was unknown. So guide us on that.
Thank you, my lady, for the question. You see, in the fact sheet, you can see that from the fact sheet, we can see that this particular that was seen on the CCTV cameras was just wearing a police uniform, but was not identified. The elements for the enforced disappearance include there has to be an arrest, there has to be a refusal by the state to acknowledge it, that they are taking up investigations, and the person has to be identified as a police officer. In this particular instance, they have not yet been identified, and until the investigations by the Director of Criminal Investigations are done, then we will attribute that to them. It will lead this person is a police officer. My lords, I would also like to refer you to the violation of rights as can be seen in paragraph 36 of the fact sheet, in which we see baby Amani's life being arbitrarily taken by the state. The blood of baby Amani, my lords and ladies, is in the hands of the state. This was no justifiable death. We can see in seeing that my time is almost up, my lord, I'd like to request for 2 more minutes to finish my submission.
1.5.
Thank you, my lord. We see that this particular right was not protected, as we see that they have an obligation to protect, as outlined in the Little Bit versus KA case, in which this same court provided for in 2021. Seeing that they did not uphold that right, and also contrary to Article 26 of the Constitution of Working and Article 6 of the ICCPR, this was not justified. And even if these police officers were acting under instructions, we see that they were, even if they were acting under instructions, we see that the National Police Act under the 6th schedule provides for when force should be used, and this was not justified.
Counsel,
Yes,
sorry to interrupt. Are you basing this particular argument on any doctrine? And if there is, could you please guide us on the same?
my lord, on the right limit this particular violation of the right to life, we are not basing it on any particular doctrine. However, in this, if I understand you correctly, and you mean in regards to the police officers acting on command, even if they were, then this command authority principle that is derived, we like to state advancedly that even if they do state that the Inspector General was the one that issued them the direction, then we completely refuse that. Inspector General should be held accountable for his actions, as can be seen. He was the one that instructed the police officers. My lords and ladies, today we have witnessed a series of injustices, and it is my hope and sincere hope that we will not allow this particular act to continue ongoing. It is in your hands to make this particular changes in favor of the rights and freedoms of the people of Ghana.
Thank you, Counsel.
Yes, thank you.
Please record. Good morning, my lords and my ladies. My name is Njapit Joseph, the Attorney General of the Republic of Working. Appearing alongside me is Yvonne Sarange. I will take 14 minutes for this short time to dispense on the first 2 issues. My co-counsel will take 14 minutes to dispense on the merits of the last 2 issues. We reserved 4 minutes for rebuttals. If this honorable court has no any clarification, I'll proceed. Much obliged, my lords and my lady. The structure of the arguments of the respondent will be as follows. First, we will argue that this honorable court has jurisdiction to determine issue B, but lack the requisite jurisdiction to determine issue C and D, because these are issues of violation of human rights, which is in the purview of the High Court of the Republic of Mbakni. Subsequently, we will argue that the matters C and D tabled before this honorable court are not admissible. Secondly, my lords and my lady, we will endeavor to demonstrate before this honorable court that the principles laid out under Article 81 of the Constitution of the Republic of Mbakni on the electoral process were adhered to on the date 6th of August during the election of the Republic of Mbakni. My lords and my ladies, election is a process. it is not a one-day event. The petitioners will want to view this election in the myopic lenses of one day. It is an invitation that we ask my lords and my lordship that we should not take that path.
Council, if elections are a process, then shouldn't we believe the petitioners that incidents which are connected to the election should be determined by us?
Much
Incidents which occur during that election process.
Much obliged, my lord. That takes me to my first argument. And it is our argument that, yes, the matters of human rights were incidental to the election of 6th of August. But, my lords, we have the High Court of the Republic of Mbakni, which has jurisdiction to determine matters of human rights. But most importantly, my lords, is the Constitution of the Republic of Mbakni. Article 163 states verbatim that the jurisdiction of this honorable court is exclusive and original in the determination of petitions to the office of the president. But in comparison is Article 165 of the Constitution of the Republic of Mbakni, which states that the jurisdiction of High Court to determine matters of human rights. For this court, it is exclusive original jurisdiction. And this one is in pursuant to Article 140 of the Constitution of the Republic of Mbakni. Article 140, my lords and my lady, says that any person can file a petition to challenge the election to the office of the president. It is the election to the office of the president, not human rights matters. My lords.
Council, before you proceed.
Yes, my lord.
From the petitioners, they say that we will be wasting the court's time if I did ask them a question. If you file human rights violations before the High Court and you file the issue of the presidential election before us, they said, if I'm not wrong, that is a waste of judicial process. Secondly, they have given us decisions which have said that it's not only the High Court which can deal with the issues of human rights violation. Do you have a problem with the principle of incidental which they have given to us? Do you have a problem with it? Do you have a problem with that principle? And do you think it's inapplicable before this court?
Much obliged, my lord. And in that case, my lord, we submit that it is not a waste of time. The High Court of the Republic of Mbakni, and my Lord Justice Njuguna was very clear in asking, will there be a harm if these matters are brought before the High Court? My Lord, we submit that there will not be prejudice. Because, my Lord, in your decision of Samuel Macharia versus KCB, you stated that the High Court, and I like the words of this honorable court when dispensing that decision, that the Supreme Court should not go on a craft to usurp jurisdiction of lower courts during election dispute. My Lord, it is a submission that it is not a waste of time. The High Court of the Republic of Mbakni is well trained. The High Court of the Republic of Mbakni is also well versed with the law. My Lord, and we invite. Yes, my Lord.
We are determining the conduct of the presidential election, and you agree there's a qualitative aspect to it. The things that happen around the election determine the quality of that election. How can we lack jurisdiction over such things?
Much obliged, my Lord. And I will dispense on a question which you asked the petitioners, that these matters occurred after the election. Some of these matters occurred after the election. Section 83 of the Election Act says that this honorable court can only nullify an election if there are matters which stress to the fundamental
so
elements.
You concede we have jurisdiction over the incidents that occurred before, like the ban on Imarisha Dada.
Much obliged, my Lord. We submit that this honorable court has jurisdiction to determine such matters which occurred before, and it also has jurisdiction to determine matters which occur after. But my lord, we submit that that jurisdiction can only come through the constitution, and Lord Justice Narangi was very clear in dispensing honors of motor vessel Leland that jurisdiction is everything, and it stems from statute or the constitution. The Constitution of the Republic of Guinea gives this honorable court jurisdiction in the following aspects: appellate jurisdiction from the Court of Appeal. It also gives this honorable court jurisdiction as an advisory court to the county assemblies of the Republic of Mbokni, and my lords, as a court of first instance to dispense matters of election to the office of the president. My lord, it is a submission that matters of human rights are matters which should be tabled before the High Court.
Counsel, you characterize these issues as matters of human rights, but from where we see it, we think of them as matters of interpretation of the Constitution. Is it your position that this court does not enjoy concurrent jurisdiction with the High Court in matters relating to interpretation of the Constitution? We would want to hear your views about that, because when you talk about human rights, that is not a qualitative criteria. The criteria that this court would want to use, and you correctly quote the case of Samuel Macharia versus KCB, we would not want to usurp jurisdiction, especially of the superior courts, but we would be interested, don't we have concurrent jurisdiction to inquire into a matter relating to the interpretation of the Constitution?
Much obliged, my lord, and thank you very much for an excellent question. It is a submission that this honorable court enjoying jurisdiction, but it is also our argument before this honorable court that the petitioners should have first exhausted other available avenues, and some of those available avenues are provided in the Constitution, and most importantly is the High Court, which is given jurisdiction to dispense on these human rights matters. So before approaching the Superior Court, they should have gone before the High Court for such dispensation.
Is that rule to exhaust mandatory? Are there exceptions?
Much obliged, my lord. To the best of my knowledge, my lord, it is in the respect of the doctrine of hierarchy. It is in the respect of the doctrine of hierarchy, which is provided in the Constitution of the Republic of Guinea, and each court is given its own jurisdiction.
Okay.
Much obliged, my lord. On matters admissibility, my lord, we submit before this honorable court, like I have already alluded to, that there are other available remedies and avenues that the petitioners will have approached. And having mentioned the High Court, I will mention the Political Parties Tribunal, which is given under Section 40, jurisdiction to determine matters on dispute of political parties. The matter on bringing Imarisha Dada political party before this honorable court, it is a submission that such matters could and should have been tabled before the Political Parties Tribunal. Onto my substantive arguments, my lords and my ladies, our arguments are...
Counsel, Imarisha Dada was a candidate in this election, the presidential election. You're telling us that the issue relating to her disqualification should have gone to the Political Parties Tribunal.
Much obliged, my lord. My lord, Imarisha Dada.
Does the Political Parties Tribunal share our jurisdiction over presidential election processes?
And what is its function, the political tribunal?
Much obliged, my lord. Imarisha Dada political party was a party which was banned for misprint and extreme gender terms, which are...
Whatever the reasons, jurisdiction over that issue, where does it belong?
Much obliged, my lord. It is a submission that first, such matters should have been tabled before the Political Parties Tribunal, which section 39 and 40 provides for jurisdiction to determine matters of dispute of election of political parties. What happened, my lord? Yes, my lord.
The Political Parties Tribunal is about disputes between political parties or in a political party, this is a candidate who is banned from the presidential race. It doesn't belong there, does it?
Much obliged, my lord. Council stand credit on that. We will get back to the court on the merits of that. Going to my substantive arguments, we will argue these arguments following three ways. One, that there was adherence of the doctrine of universal sovereignty. There was also adherence of the doctrines of transparency. There was also adherence of the doctrine of fairness in the election. And to conclude my remarks, my lord, I will allude to Section 83 of the Election Act, which provides that it is only when there is fundamental breach that stems to the fundamentals of the election that this honorable court is allowed to nullify presidential election. On the principle of universal sovereignty, my lord, we submit that there was a clear registration of voters which was done, and this was announced before the Monarchy TV, 7 p.m., 1 p.m., and subsequently, my lord, there was 85% voter turnout. Comparison to other elections, my lord, this was a huge voter turnout. My lord, we also submit that the IEMS system, my lord, which was used was a great system. And my lord, to prove this, paragraph 17, other countries lauded the Republic of Guinea for its efforts to make sure that the election goes on. And not only goes on, but amidst a pandemic, the election is transparent. The doctrine of
before you go on,
yes, my lord.
You've told us that the irregularities that need to affect the outcome of an election must be so huge. So the question from the bench is, what in your view is the standard of proof or the burden that the petitioners need to discharge to convince us that the irregularities were to such a level that they affected the outcome of the elections and therefore this petition should succeed? What is the burden in your view?
Much obliged, my lord, for that question. I was coming to that, but because my lordship has asked that question, I will endeavor to answer. This honorable court in Raila Amolo Odinga versus IEBC 2017 made a clear standard of proof that it should be intermediate or quasi. It is beyond standard, the standard of beyond reasonable. It should be beyond reasonable doubt, but it should also be beyond the standard of probabilities, balance of probabilities. So it should be intermediate. My lord, it is a submission that the petitioners clearly have not proved this case beyond and to that extent of intermediacy between the standard of proof of beyond reasonable doubt and that one of between balance of probability.
They have demonstrated, though, that 10% of the voters did not.
I will allude to that fact as I make my concluding remarks in reflection to section 83 of the Election Act. And also that one, I will look into it in reflection to the case by the Supreme Court of the United States of America in Bush versus Gore, my lord. If my lord allows me latitude, I'll go to my, seeing that my time is far much spent, my lord, I will go to my second argument on transparency.
How much time do you need to conclude?
2 minutes, my lord.
Very well, you have it.
Much obliged, my lord. On transparency, my lord, it is a submission before this honorable court that the election was transparent because there was a good integrated system which used laptops and e-books to transmit results from the tallying centers in the constituencies to the National Tallying Center. My lord, the invitation which the petitioners are inviting this honorable court to look at the voter turnout, look at the voter turnout, the 3/4%, my lord, it is a submission that when there is all that transmission from one constituency to the other, my lord, it is a submission that there's sometimes technological things. And when you have, like, for instance, my lord, I'll give a hypothesis, my lord, that if you have a tap of water and the water is running, and then you clog that up. When you release the clog, then the results will come enormously. It is our submission that the results came at once from the constituencies, my lord. On my last argument,
does it raise doubts that in 3 seconds you get half the votes coming in at once?
My lord, yes, it does raise doubt,
but
but
that speaks to transparency or verifiability of the election, doesn't it?
Much obliged, my lord. Yes, it does. But this one, under paragraph 32, the EBC says it is purely coincidental. It is upon the petitioners to prove that this was not coincidental, which they have not proved, my lord. On my concluding remarks, my lord, in view of section 83 of the Election Act, my lord, it is only when there is fundamental breach that the election results will be nullified. My lord, it is a submission that there were no such enormous irregularities to warrant this honorable court to nullify the election of 6th of August of the Republic of Mbwakni.
Thank you, Council.
Yes, my lord.
Thank you very much. Thank you.
Yes, my lord. Just to guide you as you, my lords, retire to make the judgment, my lord, is the case of Bush versus Gore, my lord, and the maxim, the minimis non curat lex of small offenses. My lord, the law knows no cure.
We will consider it. Thank you very much, Council.
Good morning, my lords, my ladies, my name is Yvonne Sarake, fellow counsel for the respondents, and I shall take 14 minutes to address this court on the merits of issue C and D. On issue C, the respondents aver that the government of Mbwakni did not violate Bogi Media Services' right to a free media. And to demonstrate this, we shall use two arguments. First, that the right to a free media is not absolute, and second, that the conditions in Mbwakni necessitated the limitation of this right. On issue D, the respondents submit that the government of Mbwakni did not violate its municipal and international obligations with respect to the protection of human rights. And in demonstrating this, we shall use two arguments. First, that the elements of enforced disappearance have not been met, and second, that the use of force by the police officers of Mbwakni was absolutely necessary and proportional. If the court seeks no clarification, I will now proceed to handle this matter substantive.
Why was it necessary to impose a complete ban? Because the petitioners say that that was not proportionate.
I believe my lord is talking about the issue of
yes. Yes.
Much obliged, my lord. And in addressing your question, Article 34 of the Constitution states that while there is a right to freedom of the media, this right can be limited under Article 33(2) of the Constitution in circumstances where there is propaganda for war, incitement to violence, and also, as has been stated under Section Part 2 of the Penal Code, Treasonous Act fall among acts that cause a disrupt to public order. And therefore, we submit that the publication or the broadcast of the Treasonous Act that was taking place in Mbwakni would cause a disrupt to public order.
Be that as it may, they were broadcasting a live event. Then after the live event was over, you shut the media station down, you revoked the licenses of the journalists. How can that be proportionate?
Much obliged, my lord. And in addressing your question, I will turn this court's attention to paragraph 33 of the facts, where the government had warned media houses against broadcasting this Treasonous Act. The government took measures to warn these media houses against broadcasting this act. And on addressing proportionality, my lord, which falls under the principle of necessity, We do acknowledge that, in fact, we do not follow the procedure that has been laid down under Section 35 of the Media Council Act that requires us to present this matter before the Complaints Commission. However, the conditions in WACMI, as has been stated, necessitated this limitation. And to further buttress on this matter of necessity, it has been stated, and as fellow counsel for the petitioner has stated, under the Siracusa principles, that we need to assess the necessity of a limitation. And in assessing this limitation, there is need to look at a social need or the social need of a particular country at that time. The need in the Republic of WACMI was that there were, and as has been seen from paragraph 34 of the facts, this situation, meaning this broadcast, combined as the word that has been used in the facts is compounded, which indicates a mixture or elaboration of this matter. It's compounded and created a lot of tension in Warazi City. And
Council, if I may, when you talk about this Prisoners Act, and that forms the basis for shutting of the media house, we feel that the person responsible for the Prisoners Act is Mr. Timon, Omoni Timon, and not the media. Why has there been no prosecution of the perpetrator of this act, and instead a media house that was just disseminating information gets to bear the brunt? And related to that, we also see that the oath that Mr. Timon allegedly took was that of the people's president. Persuade us that this is prisoners under the laws of WACMI.
Much obliged, my lord, and I will first answer your question on the Prisoners Act of Mr. WACMI and why it should be considered to be a Prisoners Act and why the government did not prosecute in the first place. My lord, in Section 40 of the Penal Code, it has been stated that treason involves a deposing by unlawful means or a purporting to overthrow by unlawful means. And as was stated in the case of SMZ versus the Republic, this is a Zanzibar case, to prove treason, you must show that this act was indeed done. This is one of the requirements to prove the allegation of treason. For us to take this matter before a court, the Treasoners Act must have happened. We cannot go before the court and cast mere aspersions that he purported to do this, because the requirements of proving the crime of treason requires us to show that indeed the act happened. Doing this before the inauguration ceremony will have no weight before the courts.
So the act did not happen?
The act did in fact happen. What we are alleging before this court, or what we are asserting, is that the arguments that we should have taken Mr. Omoni Timon before a court cannot suffice as a less restrictive measure to prevent this Treasoners Act. And also in addressing that matter, before taking a matter before a court, you have to establish a prima facie case. And this needs to have an evidentiary burden where it can be proved, or it has to carry some weight before a court. Taking this matter before a court before this act will have happened has no evidentiary facts that have been stated, and therefore we will not take this matter because it was bound to fail. And on addressing also the issue of limitation, states have a certain margin of appreciation when it comes to limitation of rights. And this was stated in the case of Han versus Turkey by the European Court of Human Rights. And this margin of appreciation gives states a discretion to take legislative, administrative, and judicial actions. And this margin is particularly wide in cases that involve national security or public order. The steps in WACMI involved such as has been shown under paragraph 34 of the facts. And we also submit.
I have a question for you. You have stated that the reason you shut down the media station is because they were broadcasting a Treasoners Act.
Yes.
You have then gone ahead to say that the Treasoners Act did not actually occur. So how do you buttress the decision to shut down the media station?
Much obliged, my lord. And in answering your question, I will clarify whatever I have argued. On the issue of using less restrictive measures is what we've argued that we could not have taken this matter before a court purporting to use less restrictive measures that would have prevented the shutting down of Mbogi Media Services because our case would have failed due to lack of evidence. However, we do submit that this treasonous act in fact happened. And to support this, Section 12 of the second schedule of the Media Council Act states that media houses or media enterprises should restrain themselves from broadcasting events that can cause sectarian conflicts or conflicts between communities. From the history of WACMI under paragraph 5 to 7 of the facts, we see that this is a country that has a history of politicization of ethnicity. It is one that where during elections or in the history, violence has erupted from differences or commotion between communities, different communities in this country. And therefore, the act by Mbogi Media Services to broadcast this was a breach of Section 12 of the Media Council Act, together with Section or Article 33(2) of the Constitution. And therefore, it was absolutely necessary for the government to limit these rights. If I will move on to our arguments under issue D, the respondents submit that, firstly, the elements of enforced disappearance have not been met, and therefore the government cannot be held responsible for the enforced disappearance of Mr. Mamini. Much obliged, my lady. First is the introduction of liberty of the person. Second is the involvement of the government, at least by acquiescence, and third, the government acknowledge that they have this person or admit that the second and third elements of these have not been met. And what our arguments, facts says that when it was discovered, it shows an identified police officer that was asking Mr. Mamini before his car could not be traced anymore. This police officer is unidentified, and we do ask the respondents that it has also been stated that it is a police officer. However, this person is unidentified, and there are instances of wrong police officers, and until this person is found and he can indeed be questioned and interrogated as to who or what he was acting on, then the respondents cannot be held liable for this.
Still,
In addition,
the fact that he was found dead means the state did not protect him. The duty to protect his right to life. That was violated, wasn't it?
much obliged, my lord. And indeed, we do agree that Mr. Mamini was found dead. However, when he went missing, the police took up action to investigate and find out where he was. And it was this investigation that led the police officer to find his body in a forest northwest of Warazi County. And also the DCI is taking up measures to look into the matter and ascertain who is responsible for the death of Mr. Mamini.
Is it your argument that lack of proof of the two elements, that is number 2 and 3, proof number 1, they cannot, it cannot suffice?
I'm much obliged, my lord.
Must they prove all of them? Must they be proved all of them?
Yes.
Or one can suffice?
Much obliged, my lord. And in answering your question, I will direct this court to the decision of LSK and 2 others versus Attorney General and 2 others, a 2018 case, where it was stated that these elements of enforced disappearance are conjunctive and they cannot be separated from each other. Therefore, for the petitioners to prove to this court that indeed the government was involved in the enforced disappearance of Mr. Mamini, they have to prove all 3 elements. Moving on to our argument for the use of force, we submit that the force that was used by the police officers in the country of Bwakni was necessary
proportional.
Council,
Yes,
the general rule during public order management is that no force shall be used. So are we seeing that under the doctrine of state responsibility, that
but there is an exception to this, and this is when it is absolutely necessary and proportional. And in addressing necessity and proportionality, the 6th schedule of the National Police Service Act states that this use of force needs to be proportional to the objective to be achieved and to the seriousness of the offense. Want to particular article, not article, rather paragraph 34 of the fact sheet, we see that when the supporters of Money Timon rioted, there was a state of economic distress in the country because they blocked the highway to the city, which under paragraph 1 of the fact has been stated is the economic hub of Mbwakni, and this is a country that is still developing. So the act
Council, you're saying the force was okay, but we have a dead baby. We're told there's a baby who's resting in the arms of an angel instead of their mother. How was the force necessary or reasonable?
I'm much obliged, my lord. And in answering your question, we do, yes, we do acknowledge as the respondents that this was in fact unfortunate. However, this happened while the respondent was taking measures to ensure that the persons who were engaged in election malpractice and were hiding in Ufukara ward were arrested and held accountable. And this is seen under paragraph 36 of the facts. And also, we do state that these are acts of individual officers. And in as much as there is the aspect of command responsibility, it does not apply in this situation. And seeing that my time is up, I'll ask for an extension of 2 minutes to conclude my arguments. Much obliged. And on addressing command responsibility, Article 28 of the ICC statute states that for command responsibility to be asserted, there has to be an existence of a superior subordinate relationship, that the superior knew or had reason to know that the criminal act was about to be or had been committed, and that the superior failed to take necessary and reasonable measures to prevent the criminal act from happening. We submit that this is not the case in the Republic of Zimbabwe. When the Inspector General deployed the police officers to go and contain the situation, he asked them to act decisively. But the police officers, some of them went ahead and acted viciously. While we do acknowledge, yes, that it was unfortunate that Mama Amadi was assaulted and Baby Amadi was killed as a result, this act cannot be attributed to the state. And in accordance with the requirements under the 6th schedule of the National Police Service Act, the Inspector General, as well as the government, is and all undertakes to collaborate with IPOA and ensure that these individual officers are investigated and, in fact, that they are held accountable for whatever happened in Ufukara ward.
Were they acting in the course of their duty?
Much obliged, my lord. Yes, they were acting in the course of their duty, but in an excess of whatever they were supposed to do.
You admit that your client acted unproportionately, disproportionately.
Much obliged. My client is the Inspector General, and in addressing this, we do state that the Inspector General cannot be held responsible for the acts of his juniors in this situation because the two elements of having knowledge that a criminal act was about to be done or failing to take necessary action have not been fulfilled, and therefore he cannot be held liable. However, we do acknowledge that these individuals did in fact violate these rights, and therefore they should be held accountable, and we are taking steps to ensure that this in fact happens.
I think Justice Isabella had a final question for you.
that has been captured.
Very well, thank you, Counsel.
If this court may grant me the discretion.
We'll see them from your memorial. Thank you very much. We've come to the rebuttals now. Okay, the appellants had reserved 2 minutes for rebuttal, and the respondents had 4 minutes left. Okay, so you can have your however, we informed that the respondents actually spent 28 minutes. So you reserved 4, but spent 2 during the main argument. So both of you have 2 minutes. Proceed, counsel.
My example, I shall seek to address 3 major thematic areas beginning with jurisdiction. My lord, they have referred you to only one case which affords this court jurisdiction, this court's jurisdiction, and it is that of 1989 Lillian S. It is our submission that if you go to paragraph 248 of our interim independent election commission, you will find that the emeritus chief justice stated that judicial principles laid out can be used as the basis of jurisdiction. Secondly, my lord, we submit that if you go to Mazoka Kambala versus Mwanawasa in the Supreme Court of 2002, in the Supreme Court of Zambia 2002, anybody who is entitled to vote, when presented with the opportunity to vote, should be allowed to vote. My lord, it is our submission that that did not happen, because regions were moved from gazetted areas to non-gazetted areas, affecting over 10% of the people. And again, my lords and my ladies, let us not take this issue of baby Amani lightly. My lord, that will be your son, and my lady justice, you will be Mama Amani. And my lords, in general, we need to note that baby Amani might have ended up being a chief justice or a justice of this honorable court. And therefore, let us not take it as another statistic. Lastly, my lords and ladies, how do you aid and abet something that is not there in the first place? Because they have averred that there is no treason. However, we are aiding and abetting treason. With that, my lords and ladies, we seek to ask this court in front of the people of Mwakni who are watching, in whose hands are we safe? In whose hands are we genuinely safe, if not those of this court? With that, the petitioner rests their case.
Thank you, counsel.
It is true that it was the killing of baby Amani, but under what circumstances? The principle of necessity. But the petitioner asserts that we have only submitted before this court the locus classicus Lillian S. It is evident that the petitioner did not hear us submit on Samuel Macharia versus KCB, where this point of court mentioned that it cannot go into a craft of usurping jurisdiction of law. But to add to that, matter, is your decision in Isaac Electoral versus IEDC. You mentioned that when the rules are clear, when the statute is clear that jurisdiction is provided, then this honorable court cannot usurp jurisdiction. But on the doctrine of incident and concurrent jurisdiction, we submit that the doctrine of supremacy of the Constitution should supersede that. The Constitution of the Republic of Mwakni provides the jurisdiction of the High Court. It also provides the jurisdiction of this honorable court. My lords, our final remark will be in reflection of the decision of the United States of America case, Bush versus Gore. Let the people of the Republic of Mwakni decide.
Thank you very much, counsel. We will retire and we'll come back with a decision. Thank you.
All rise.
So thank you for your time. We are now proceeding for our tea break. Then the closing ceremony will begin at 11:45 a.m. So we will just go to the rooms we'll be going to for our tea. Thank you very much.
1, 2, 1, 2. Check 1, 2. Napata. 1, 2.
Good afternoon, everyone. So we are now beginning the closing ceremony of the 10th edition of the All Kenyan Moot competition. I will be taking you through the program. My name is Martin Kyoto. I'm a student coordinator. So we will begin with a prayer from Emmanuel. Then we will proceed to the two speakers of the house to take us their work. Emmanuel, please. Let's kindly stand for the opening prayer. Have been in the competition for the longest time. Some from the beginning, others for the last 5 years. We will be hearing from them the experience as partners. We also will look at competition for that time. They will tell us some of the good they've experienced in the competition and what they foresee as the future of the competition. So we have represented here SNF Foundation, which is the first Women's Foundation for Freedom. We also have the Raoul Wallenberg Institute. We have Kenyan Law, that is the National Center for Law Reporting. Giving us we'll have a judge representing the judges who mark the memorial, and then we'll award the winners for the memorials. Then we'll have a judge representing the judges for the research category, who will talk to us about some of the areas of improvement. Then we'll also listen to the presiding judge for the final round to speak about the oral aspects of the moot court competition. Thereafter, we'll have some short celebration of our 10th anniversary.
Yeah, they have been ambushed, but I'll try. Yeah, let me say this, that I'm very happy to see you today, Friday, and for the guests that were not with us on Monday, we're very happy. We are very grateful for the support that each of you has given us. You graced the occasion for the students, and also you prepared for the competition. So you raised the level of the competition and contributed to jurisprudence on electoral law. So we are very grateful for that. And you made also the week very interesting for all of us. And to our judges, we are very grateful for your time and your expertise. Thank you very much. So my role now is a very simple one, to invite the guest who is going to speak to us, Lilian Kanyingi, who is a program officer in F&F. She'll tell us a little more. Yeah, and then I think that's my role. Thank you.
Wow. So this is the morning of the ambushes, but good morning. Good morning again. So it's an honor to be here. My name is Lillian. On behalf of FNF, we just want to say we are very grateful to have been invited to this wonderful occasion. It's our first time to partner with Moot, and we'll be doing it again. At least that I can say, on behalf of FNF. Sorry, we were only able to attend the opening ceremony. We've not been able to attend the competition, but a couple of our staff have been following online. Very exciting. And I wish to take this opportunity to congratulate all the participants. Great work. I mean, great speakers. And again, it's an honor to be in this presence. And I was gonna, because now it's a little late to say may the best team win, but we are happy to receive the results. I'm sure everybody is crossing their fingers. And welcome to this part of the ceremony, and let's enjoy the rest of the section. Thank you very much.
Thank you very much. I will now invite Dr. Kabata again to give the FNF Foundation, and I will ask Ms. Lillian also to pick the gift on behalf of their directors. Please clap for them. Yes, thank you very much. And we look forward to partnering with the FNF Foundation for Freedom in the subsequent and future moot court competitions. I will now invite Ms. Isabella Obaram, who is representing the Independent Medical Legal Unit, to also speak on behalf of her institution. Please clap for her.
Good morning, everyone. I can confirm that I was not ambushed. Everything is well. Thank you so much for having us. And I say us on behalf of the Independent Medical Legal Unit. And for everyone who is here and they have never interacted with our organization, this is an organization that has been in practice, or rather offering services to victims of torture and related violations for about 29 years, 5 months now. And Dr. Kabata, I'm looking at you smiling because I want to say thank you for the continued partnership. We are happy to work with KU, not now only, even in other partnerships. We are currently looking at other areas of, working with the students outside of the moot court. This is not our first time. We worked together last year, and I can see some of the people we worked with. Thank you very much for having us. We also worked in the 8th edition, right? So this is a continuous process. You are an ardent partner, and we are happy to see what the journey looks like for us. I had written something small specifically because we were asked to talk about engagement. It has been a pleasure engaging with you, to the steering committee, the students, and every single person who brought forth this particular moot court. We want to thank you. And as IMLU, we will keep working with you as long as we can. Thank you.
Thank you for that. We also have an award for you. I will ask Mr. Timothy Thondu, President of the All Kenyan Moot Court Competition in the 6th edition, to give the award on behalf of the competition. Please clap for them. Thank you very much. I will now invite Mr. Ian Chelal, representing the International Justice Mission. Please clap for him.
Distinguished guests, fellow students and lovers of the law, good afternoon. I am encouraged and I'm extremely happy to stand on this podium today as a former student of this school. I sat in this very, very room not too long ago. I'm extremely happy to even have the Dr. Bata here, who taught me human rights, taught me evidence law, a big part of which I practice in my career currently. As IJM, we are thrilled. We are extremely happy to continue with the partnership we have with the Moot Court competition. And much credit to Kenyatta University for your consistency in seeing this through. I must credit the steering committee, Mr. Alex, Mr. President, and the entire team. You are an incredible, incredible team to work with. And it is because of having such people like you that it even makes it easier for us as non-governmental organizations to partner. I think the theme of this year was very timely. Elections in this country is a very worrying time. If you have some time, kindly visit www.missingvoices.com and you will violations spike. We talk of cases such as the Dependo. We talk of dozens and dozens of other cases. It is a very worrying time, but I am encouraged by the discourse that I saw in the past week, the exchange, the brilliance that I saw, and I believe, and I strongly, strongly believe we will manage to address these issues. I think allow me to single one thing that I saw quite brilliant. One of the councils in the final round quite brought out the elements of enforced disappearance with such poise. Where is she? It was very, very encouraging. And it is because of it is because of you. It is because of you, students who stand up for human rights, that we have the courage to wake up every day and continue fighting. Ourselves as IJM, we partnered before and we will continue partnering. It is not a question to us. Every single year in our budgetary allocations, we always ask ourselves, how much money should we set aside for the Moot Court competition? Because we know the value. We know the value that it brings. And I just want to say we are encouraged. I'm particularly very thrilled. And congratulations to the winning team. Looking forward to seeing you again next year. Asanteni sana.
Thank you very much, Mr. Chelal, and of course to IGM. So you will receive also a gift on behalf of IGM. It will be presented by Mr. John Mwasa, who is the Deputy President of the All Kenyan Moot for the 10th edition. Thank you very much. Now we'll hear from our partners who've also been with us for some time. That is Kaplan and Stratton Advocates. They're represented here by Mr. Wycliffe Oyo. Please clap for him.
Good afternoon, everyone. You've heard my name is Wycliffe Oyo. Others say White Life Oyo, depending on where you went to school. And I work at a small firm called Kaplan and Stratton Advocates in Nairobi. On behalf of the firm, we are elated to be here today, and particularly that we are celebrating 10 years of engagement with the All African Moot. It is no mean feat. When you look at the board here and look at the number of sponsors who want to be associated with this thing, it's a big thing, and we must all clap for ourselves. Can we give ourselves a round of applause? So the firm prides itself in legal excellence, in best practice and outreach, and we will continue to partner with this moot and all other moots that are trying to help the young ones coming through to get a feel of what it is to be a legal professional. And right now we stand at a position where the difference between a legal professional and a quack is not very easy to discern. And we must therefore be very deliberate and careful as to the way we mold the young ones. And Ms. Dean, you are here. The values we espouse in these young ones from the very beginning will inform what kind of legal professionals we have out here. And as a firm, that is our commitment. And that as a firm, that is what we are coming to tell you here today, that we support the moot, both in spirit, in finance, and in prayers. Away from the farm, I've also had an opportunity this morning to be a judge in the final rounds. And from what everyone has said, when we lose confidence in the legal profession, some of you, like those mooters today, restore that confidence. You can see that the future of the legal profession is in safe hands if the arguments are anything to go by. So I want to heartily congratulate those who presented today for the erudite arguments, the poise in the manner they answered our questions, and the clarity of mind they have in matters the law, even at this early stage. It's admirable. Secondly, I want to say that let's not only make this about moots, because the word moot means mock. We are going into a world where we will be litigating real flesh and blood issues, and I think that should be our concern. Let's look at the legal profession. Let's look at where we stand right now, and let's define our role in the wider spectrum of things. I say this with particular difference because I am someone you could classify as a young lawyer. I'm doing my 6th year in legal practice, not very young, you may say. It's the body that is deceiving. But the thing is that we have seen the numbers in the legal profession rise rapidly. 6 years ago, when I was called to the bar, I was number 13,329. As we speak right now, that number is well over 21,000. It means in 6 short years, we've had over 7,000 members coming to the bar. The legal market has remained invariably the same. The number of law firms has not gone up so much. And we have the threat of technology trying to take away our work. The result of this is the space of a young lawyer is now very diminished. And that requires, as a matter of necessity, that those of us who are young, those of us who are coming through, must be innovative, aggressive, and seek to take our rightful place in the profession. And there is no better place to start than here. I want to urge you this afternoon to not only take these moot court sessions as things where you come and make theoretical arguments before a bench, but as very serious things that will define who you are when you finally come to the profession. Because I can assure you, when I go back to the firm, what kind of recommendation do you think I'm going to make to the partners? I'm going to make a positive recommendation in respect of those who presented before us. Is that not the case? Is that not how we open up opportunities for ourselves? I want to challenge each and every one of us to locate our legal field, to locate our place in the profession as early as now, and seize that opportunity. Last, I know you would want to listen to me all day, but we have other speakers. I want to come to the theme of today's debate, or this week's debate rather. You've been told that the country now stands at a precipice in terms of our general elections that are coming up. You live in this country and you see the manner of things the political class is orchestrating in the name of campaigns. I want to urge us to also take our rightful place in not only informing the public about matters elections, but also actively engaging as aspirants, as civic educators, as dispute resolutors, and in all other areas where the lawyer can provide guidance, and especially in light of what we witnessed in 2007, which has in a majority way affected the question for this year's moot. Let us all endeavor not to go back there. And I can't think of any other better professionals than lawyers who offer this useful guidance. More importantly, take up your rights under Article 81 of our Constitution and vote. We say my professor in the university used to tell us that when they were growing up, their parents, guardians told them that politics is dirty. So they left politics to crooks who mismanaged everything. But political business is first and foremost economic business. And I assure you, any argument to the effect that politics is dirty and I must stay away from it is an ignorant argument, because politics affects all facets of our lives. So I urge us to take up that responsibility to vote, to influence the leaders of now and tomorrow, and to probably have a better country than we already have. May God bless you and your villages. Thank you.
Thank you very much. Mr. Yo clearly sees that the future of this moot court competition will go beyond the country, probably throughout the continent, and we hope to have impact as you foresee it. Thank you very much. I will invite Mr. Dominic Njuguna, one of our judges in the final rounds, to award Kaplan and Sutton advocates. Please clap for them. Thank you very much. Another one of our key partners throughout this 10-year journey has been the National Council for Legal Reporting, and we are privileged to have the Chief Executive Officer with us today. So I will now invite Professor Jack Mimali to speak on behalf of Kenya Law. Please clap for him.
The invited guests, the dean, colleagues who are around here, the students who have participated in the moot, and those that are here to witness the closure of the ceremony. Good afternoon. I can see I have just become a supplanter. Amongst us, there is one of our board members at the National Council for Law Reporting, Dudley, who is also a close friend of mine, and at one point my advocate. I can also see my colleague, Mamboi. So I'm just thinking perhaps the opportunity was not mine. Nonetheless, I'll have one or two things to say. I have been associated with this moot from its inception. I actually did attend the very first moot for the All Kenya Moot. And we have made great strides since those days when we started the competition to where it has reached. It's one of those avenues that create an opportunity for students to interact with the real practice of law. And every time I do attend on these moots, I see how promising we are as a profession. Personally, I know how beneficial having been a mooter it was for me. For those I have taught, I've actually explained previously that by the time I was applying for my scholarship for masters, the only thing that I could think of that made me qualify was that I had participated in the regional rounds, the South Asian regional rounds of the Philip C. Jessup Moot. Those who beat us in the finals in the regional competition went on to emerge second when they went to the universal rounds in Washington. And of course, every time I mentioned in the applications that I had made that I had participated and I had been beaten, I was given the opportunity to further my education because it probably showed that I had some promise in the manner in which I could actually also compete. What am I saying? We are all winners, even those who may not take the trophy. There are benefits that accrue to you, both the fact that at least you have something in your profile that you have participated and in the knowledge and experience that you have now gained. And I know for those who are winners,
you have done well in that you have given your time and effort and you've given your best. So I want to say congratulations to that team that has won. And for those that have not won, I think the opportunities abound for you to excel. You have already done exceptionally well to go through the processes and stages in the competition. And this is not the end of it. I know you are preparing for real life practice. There are those who are very good in terms of articulation of issues orally, and they may do very well on the oral presentation. But I believe there are also those who do well in the preparatory stages, where you are preparing the memorials, you research and look for the core issues that you must discuss. And even for those, because they may not be seen at the front line of these competitions, still those efforts are what makes a good lawyer. And therefore, I want to also congratulate those who did participate as researchers rather than the express motors in the competition. I do not want to take much more than that time that I have taken, otherwise than to wish KU greater prospect in future in this in the Kenya Law Moot, in the All Kenya Moot, and we are hoping to continue to partner with you in future to make sure that this moot actually continues to create excellent lawyers for this country. God bless KU and God bless All Kenya Moot. Thank you.
Thank you very much, Professor Mimali, for the prayers of blessing. I will now invite the Dean of Kenyatta University School of Law, Dr. Faith Kabata, to award Dr. Mimali on behalf of Kenya Law. Please clap for her as she comes. Dr. Kabata, just before you take your seat, I think you'd be kind to speak on behalf of the organizers of the competition so that you also pass our gratitude to the rest of our sponsors and partners who could not join us today.
Yeah, I'm sorry about that. I forgot. Thank you very much. Our partners who've been able to be here. There are others, as we can see, who are not able to join us for the closing ceremony, but a lot of them were with us on Monday. So we want to pass our appreciation to each of them. And I'm also informed that I should bring best wishes and regards from the patron of the AKMCC, Professor Gitu Muigai. He's not able to join us. He thought he could and he tried his best, but he's not able. So please receive his regards and his appreciation for all the effort that you have put and the way you have again contributed to the jurisprudence in that area of law. Thank you.
Thank you very much also, Dr. Kabata. You have been far too kind to the committee and you're also grateful for your support throughout the competition. Please clap for her once again. So we'll now move into the other segment of the closing ceremony, which is the awards, and we'll begin with awards from the research category. However, before that, I will invite Ms. Omboi, who is representing the judges for the research category, to speak briefly about some of the expectations, their feeling of how the competition went, some of the words of advice they will have to all the participants for this edition and for future editions. Please clap for Ms. Omboi.
Thank you to the Dean Kenyatta University, to the partners present, fellow judges who are present throughout the whole moot and research category. Good afternoon. Yes, my name is Omboi Kamau. I represent a team of 5 judges, and allow me just to introduce them. There was Judge June, and there was Linda Gishohi. There was also Judge Emma and Judge Cindy. I believe, thank you. The researchers were able to interact with them. I stand here just to give feedback of what happened during the research category and just to appreciate all the researchers that did their best. We had a fulfilling 2 days, that I can assure you. I personally felt that this was a worthy competition, and we could actually appreciate the various gifts that you could see in the different layers in the making. I can confirm to the partners present, we have upcoming politicians here. We have policy makers, we have lecturers, we have advocates serving both on, yes, we have advocates serving both nationally and in the international for, I can confirm that for sure. And we were actually very, very impressed. Out of the 23 participants, we listened to 22, and it was very difficult coming up with the final 3. So we actually narrowed down to the final 7. And what we did for the first time, we requested the Moot organizing team, of which they graciously accepted, to have a round of the, not really finals, just to showcase to the other researchers what a good research is all about. You'll agree with me, we all get to see what a good Moot is, right? From the preliminaries to the quarters, to the semis, we all get to know, and you can easily narrow down and say, how and watafika mwisho. But what about the research category? And I could tell you, for us, we could see the different gifts that are within us as individuals coming out so clearly. And we felt that if this is exposed to the other researchers, they will actually gain. And at this time, allow me to just appreciate the researchers in the room. Would you kindly stand? The researchers that actually presented, kindly stand. I hope you're here. I hope you're listening. Yes, I can see them. Yes. Thank you very much. Thank you. Thank you. You may have your seats. No one gets to see these people. No one gets to see them. And I can assure you that they did an amazing job. So what were we looking at when we were reviewing the research category? We were looking at the papers, whether they meet the set criteria of the research paper, and the paper needs to meet the qualifications that could fit in a journal. Those are the first 2 steps. And again, the presentation, you need to meet the time element, the 10 minutes. Out of 22, only 4 met within, they were able to present within the 10 minutes, but that is just the first step. It's a way for next year, try again. We kept on telling them, go practice before your peers, present before even yourself. Make sure you remember, and I think we have one of us here, one of the judges who was presenting in the BBI, you could see him, Judge Dudley. You're given time and you need to present within the time. And actually you realize the ones who presented within the time limits were able to capture everything at a moment from the very beginning to the very end. And again, there are some things that we wanted to see as judges, that you narrow down to a theme on electoral malpractices. There are very many electoral malpractices. If you focus on everything, you'll most likely lose your point. You'll go and talk about other issues. So there are people who are able to narrow down to particular themes. There was socioeconomic theme that was coming about. There's a political theme that was coming about. Then again, we wanted to see what is your voice, what sets you apart. As Kenya law, we actually compiled cases emanating from the Supreme Court, Court of Appeal, and High Court. Not every case goes into a law report, only the cases which are precedent setting. So for you, as you're doing your research, ask yourself, what is it that I can bring out here that can bring out these points? So remember, even as you're doing a paper, it's just not for you as a person, it's serving a local audience, even an international audience. So set your bar quite high. Again, allow me to say, be yourself even as you're writing your paper. We want to see these unique attributes that are coming out even as you present. We want to see them in the paper. And I'd like to respond to one of the judges who said, we are how many layers right now? About 20,000. But I can tell from the research and the 2 days we had, I can tell you for sure, each of us in this legal profession has our space. I will tell you, and that came out very clearly. You could tell people who are very passionate about economic matters, and they brought about the socio-economic aspect. The people who brought about the political theme. So I can tell you for sure, encourage yourself. There's space for each and every one of us, but you have to be passionate. I must say we were a bit disappointed because in the morning, we actually requested the researchers to come around. We only had we had a big team, but the researchers who came were actually not more than 5. Only the presenters and a few others. That tells you, where is your interest? Are you doing it just for the competition or just to learn? So always keep trying and ensuring that you want to improve day on day. Reference your work, back up your arguments with a lot of referencing. There's a lot of material out there. Thankfully, we're in an age, we're in a digital age whereby you can find information in every aspect. There's one researcher I would like to commend that he actually gave us even a list of references, articles in a whole, he printed and he went back to all the way the years searching for newspaper articles. You can see the effort in that researcher. And he tells us these are the list of authorities. Secondly, these were the articles that he referred to. That was quite impressive. Then again, make a difference between your work as a legal scholar and normal writing. Remember, you're a lawyer, you need to bring out the legal issues. Then set the stage for you to write more, challenge yourself to more competitive competitions. And I think they're upcoming. Look out for, there are many that Kenya has. So try and expose yourself to this competition. I think you'll better yourself with time. Thank you.
Thank you very much, Ms. Omboi. We now proceed to the awards. We begin with the medals. So I will invite Judge Linda Wairure to award the second runners-up. So the second runners-up in the research category is Shina Kuchie from Strathmore University. Please clap for her. We'll then proceed to the first runners-up. They will be awarded by Judge June Jumbari. So the first runners-up in the research category is Clint Otieno from JKUAT Karen campus. I will invite again Judge Wambui Kamau to invite the winner for the research category from the University of Nairobi. Please clap for Trevor Kamau.
This Trevor is the one who came with the list of authorities. He had a very extensive research. His paper met his and the presentation worked.
Thank you. We now have trophies again. So we have trophies for the runner-up and for the winner. So I will invite Mr. Ian Chelal on behalf of IJM to award Mr. Clint Otieno the runner-up winner for the research category. Thank you very much. I will now invite Professor Jack Mwimali on behalf of Kenya Law to award the winner for the research category, Mr. Trevor Kamau from the University of Nairobi. Please clap for him once again. Oh, I'm told there's a hoodie as well for the winner. Yes, thank you very much and congratulations. We now proceed now to the awards for the Moot category. The Moot category is divided into memorials and research. I will first begin by inviting a judge for the memorials to speak about the writing skills of our Moot category. So please clap for Mr. Timothy Thondu.
Good afternoon, everyone. I think I wear very many hats. I marked your memorials. I sat through the preliminaries over up until when I sat back during the finals to listen to your arguments. Before I begin, I think it would be important that I pay homage to two of my best lecturers who are here, Dr. Faith Kabata and Professor Jack Mwimali, who taught me the best. I think those are the best A's that I ever got when I was in law school. Because I usually say as a lecturer, you have two things that you need to do. You have to have the knowledge and the ability to transfer the knowledge from yourself to the students. So I'll request that we clap for these two lecturers, among many others that are here. And that is me honoring them. Number two, as I said, I wear many hats, and I'll get to the last hat, but I also served as the president of the All Kenyan Moot Court competition. Exactly 4 years ago. Thank you. That must be the committee. About, I think 4 years ago, I also stood in this very position. And to see the growth that the competition has had over that period of time up to now, it's tremendous. And I think the committee, Alex, Mr. President, and your team, you deserve a very hearty clap for the work that you have done over this period. Number three, I had the very privilege of some of you appearing before me as a judge during the all-road category. I will not speak much about that because the presiding judge for the final round is here. But what I can say about this, number one, and this needs to be very clear, it was nothing personal. Yeah, nothing, absolutely. I might have grilled you very much, but the idea behind a MUTA is not just your ability to know the law. It can never be that. Your idea as a MUTA is your ability to be able to think on your feet. You're able to turn the questions that are asked to your opponent to something that favors you. And you are able to also simultaneously sieve through the questions that each of the judges is asking you, analyze them, synthesize them, and respond to each of them. Do not be creative in trying to answer one question because it was the last one that was asked. That's why we asked a lot of questions, and they're within line to ask you so many questions. So when you're practicing for moot, and this is a request that I'll make to some of you, and actually all of you, because some of you might end up, those who are in your fourth year and you're going to Kenya School of Law, and you'll be mooting there. Very serious moot competitions in this country require you to be an agile mooter, not just somebody who has the knowledge of the law, but somebody who can apply that knowledge into the present situation that you're in. So if you're able to do that, and some teams were able to do that, congratulations to you. So when you're able to stand firm when you're answering questions, those are the things that we tick off in our oral. We don't just look at, oh, you know the law, okay, fine. No, we look at so many other things. But as I said today, or rather my duty right now is not to speak about the orals. Mine is to speak about the memorials. The memorials are a very big and integral part of you as a competitor. So do not assume that you'll have very good oral skills and thereafter fail to present those oral skills in writing. You know why? Dudley will tell you, in the Supreme Court, you have 3 minutes. And most of the things are, we will make reference to your submissions, counsel. Kindly take your seat. So what happens if the submissions that you had on paper are terrible, but you are very good and confident in terms of speaking? You end up losing. And that is exactly how moot is. So if you're a good orator, then your memorials ought to be as good as your oral skills. So you cannot negate the fact that you will be orally submitting before court and then forget that you require to have very sound memorials. And that is the gist of it. You need to have very, very, very sound memorials. And what do I do? Or what were we looking at when we were looking through your memorials? The first thing, you had been given rules, very, very elaborate rules on what your memorials should look like. You were given the kind of pages that you needed to have been done. You were given the format that you needed to have gone through. And I know some of you who are very creative will come and tell me that we should not give due regard to technicality. Yeah? But unfortunately, in this instance, that would have been something that would have made you fail. So if your pages were upside down, you have very, very, very good arguments, but I cannot be able to follow the train of thought, then I cannot award you marks. I will definitely cut you on marks. Number 2, you were given word limits. Yeah? You are told you have to be within this number of words. If you exercise creativity and go beyond that, and then assume that you will make a case for yourself, unfortunately, you do not have that opportunity. So stick to the rules, because in this time, you do not have the opportunity to defend yourself other than during your oral submissions. That is the second thing. Number 3, you need to be very sound in your argument. We had the opportunity, or each of you had the opportunity to give us memorials both for the respondent and for the applicant. And I dare say this, in mooting, you cannot present yourself and fix your mind only on one side of the case. You will fail terribly. Because if that coin is tossed, yeah, and it ends up in the side that you are not very well prepared, then you're cooked. Yeah. So same thing to the memorials. You cannot be offering very strong memorials on the side of the respondents, yet when it comes to the applicants, they are terrible. It doesn't work like that. Okay. So all these things holistically made each of the judges that marked your memorials look at the aspects of time, the aspects of wording, the aspects of following the rules, your substantive arguments within those memorials, and finally, how you brought out the issues. So if you know you didn't even bring out those issues as much as possible, you knew very well that your wording was here, the other one was there, please don't expect a trophy. And that is in no way saying that you did not perform well. You did, but there's somebody that performed better than you. So congratulations to each of you, but what I'd urge you, this very competition is what created who I am today. And it's not just this competition, many other competitions that you go through when you're in law school. Don't just sit there as a student and assume you just came to learn. There's much more to learning and much more to law school than just sitting in a class, okay? So I assure each of you that even after this, whether or not you're the winner, it does not matter. Find more opportunities, create yourselves. So Ms. Mboya has said very well, there's space for each and every person. I thought I'd be a litigator. I'm now chasing things in the community, huko mashinani, utanipata Mathare, Dandora. There's space for each of us. So please do not feel discouraged if you did not pass through this round or did not make it. There are other opportunities for you to grow, and we'll talk more regarding that. I apologize, Mr. President, for taking so much time. I think we can now get the awards for who won the memorials. Thank you very much.
Thank you very much, Mr. Thondu, for those very kind words of wisdom. And I hope we'll have better memorials in the coming competitions. So we will now proceed now to the awards, and we'll begin with the awards for the best memorials. I will again invite Mr. Thondu to award the team that won the best memorials for the applicant.
So the best applicant memorial goes to team 10004, that is Catholic University of East Africa.
There's supposed to be two of them, I believe. So he'll receive the award on behalf of the teammate. Thank you. I will now invite Dr. Victoria Miandazi to award the Best Respondent Memorial, and I'll ask you not to go very far.
Very well. So the Best Respondent Memorial also goes to team 10004, that is Catholic University of East Africa. Let us continue clapping for them. Congratulations.
Thank you very much, Dr. Miandazi, and congratulations to the Catholic University of Eastern Africa. So we'll now proceed to the other segment of the moot category, which is the oral presentation. And before we award the winners, I will invite Mr. Dudley Ochiel, who was the presiding judge in the final, to speak briefly about the oral presentation throughout the competition and also to advise our participants. Please clap for Mr. Ochiel.
Thank you very much. I wasn't here over the week, but I was here today. And from what I can see, we have really good oral advocates amongst us. Congratulations for the great work that you did. The first issue is about questions. We asked you a lot of questions. And we are not really looking at the merits of the answer, but your technique in answering, because this is about advocacy, this is about persuasion. And a good technique would be to directly say yes, and yes, but yes, however, or no, however. We are trying to see how you deal with your weak facts. We'll ask you about your weak facts. But isn't this the case or whatever? You could answer no, but yes, still. I mean, first of all, give us a direct answer and then explain your answer. And also checking how you weave away from us, how you move away from our grip in the question to your next point. So you answer and then immediately you go back to the point you are making before, conclude it, or you move to your next argument. There's no hostile question because the questions indicate the points where we want you to persuade us. And it's really helpful for you to know what the bench is thinking. And also the issue of eye contact, addressing, not just answering the judge who's asked, but also the others, because the others will also have to make a decision. So you give me one bit of the answer, then you turn this side and you give the other bit of the answer to that side of the bench, and then finally you give the closing bits of it to the judge, to the extreme, the other side. And if you don't understand the question, you can say, I don't understand the question. If a judge does not rephrase it for you, if you don't know the answer, we also check whether you are willing to concede that you're not quite familiar with that doctrine or that principle. That's acceptable. I think that may be better than trying to wing it, trying to give an answer you're not quite sure of, that you're not researched and is not in your memorial. Remember, it's not about the merits, it's about the technique of argument, the presentation. And there's something that I personally love, and I saw some of you do, the bit of hijacking questions. The question was asked to the other side, then you hijack it and use it in your own case. You are allowed to respond to questions we had asked earlier on. If we ask it to the appellants, the respondents can hijack that question. You had posed this question to the other side. Our response to it is this. Or if we ask it to the respondents, then during the rebuttal, the appellants can also use the rebuttals for that. Your introduction of your team members, we call this a signpost. We are going to address point 1 and 2. We'll argue this and that. That was quite good. Your introduction of your colleagues, your address to the bench, there was courtesy, my lords, whatever. That was really good. And the technique of addressing a mixed bench, my ladies, my lords, I mean, that address was quite good, came out well. The technique of reserving time for rebuttals, that was quite correctly done. And also just the way you delivered your arguments. I think at some point you might have seen us, those of us who are not so careful on the bench, clutching our chests, because we were identifying with their arguments. That was quite persuasive. And your application of the law to the facts of the case, your knowledge of the memorial was quite good. You could pick out which facts. There's a point I think we asked an incomplete question, and one of you was like, okay, you are asking about this. This is our response to that. You are able to identify which facts lie where in the record. I think also your reliefs and prayers. I think there's a team that had not done it, but still they did it. They recognized that we haven't done this, and they asked us for the reliefs at the end, which was good as well. Your composure, the gesticulation was okay. No extreme gestures. You are gesturing within the box, just in front of you. I think that was quite good. If there's a difference between the two teams, I don't think it would be such a big difference. It's just that in a competition, there has to be a slight difference between the two sides. It's not in your own ability. The competition, I mean, there will have to be a slight point of difference, but both teams were equally good. On behalf of Katiba Institute, we have volunteer positions for all the teams in the finals. The final So guys, when you're in between your semester, you can come over and claim that volunteer position. And you're also free to attend court with us on any day. We have quite interesting cases once in a while at the Supreme Court and through the other courts. You're welcome to go to court with us. Thank you so much.
Thank you very much, Mr. Ochel, and we're also grateful for these opportunities. We now proceed to the awards, and we will begin with the best oralist for the first. We'll do the first being the best female oralist, then we'll have the best male oralist. So I'll invite Judge Isabella Obara to present the award to the best female oralist.
So the award for the best female oralist for the 10th edition of the All Kenyan Moot Court competition goes to Wanjala Faith Kalai from Kabarak University.
Thank you. I will now invite Judge Frank Kingori to award the best male oralist. Please clap for him.
The award for best male oralist in the same vein goes to Daya Jesse Wallace from Kabarak University.
Thank you very much. We have a special award in this edition, which is the award of the best overall student. I will invite the deputy head of Moot to announce the best overall student. And I will also invite Ms. Lillian Kanyinge on behalf of FNF to award the best overall student.
So the best overall student, and I'd like us to know that this is the first time we're having this award, is Shamia Muchesia from Strathmore University.
Allow me to say a few words about this young man, because he appeared before me yesterday. This young man was sweating, terribly sweating, when he appeared before us during the semifinals. And the way he put out the case of both the respondents and applicants was admirable. So I think we should give him another very hearty clap for his work.
Thank you very much, and congratulations. We'll now proceed to award the best team. And of course, we'll announce the second runners up first, and the first runners up and the winners. I will invite Ms. Janet Karemi, the head of the Moot category, to help us mention these awards. For the second runners up, I invite Judge Dominic Njokona to award the second runners up for the Moot Court competition. Please clap for him.
And the second runners-up of the All Kenyan Moot Court 10th edition goes to 1019 from Strathmore University.
Please clap for them. I will now invite Judge Felix Mogendi to award the first runners up for the Moot Court competition.
Now from here, I'll need some drum rolls. The first runners-up of the All Kenyan Moot Court 10th edition goes to, drum roll, goes to 1007 from Kabarak, from Strathmore University.
This is a very commendable performance. Strathmore University has taken the third and second place. Please clap for them once again.
Congratulations.
I will now invite again Mr. Dudley Ochiel, the presiding judge for the final, to award the best team for the 10th edition of the All Kenyan Moot Court competition.
And the best team is University of Nairobi.
The University of Nairobi has done very well because they've won both the research category and the moot category. Please clap for them. We also have some hoodies for them. We have two more awards. We also have the award for the best overall oralist, and I will invite Dr. Faith Kabata to give that award. And the best overall oralist for the 10th edition is Mr. Thaya Jesse from Kabarak University. Please clap for him again. Now, this being the 10th anniversary, we also came up with another award, which is the award for the spirit of the moot. And I'll invite the president of the All Kenyan Moot Court competition for the 10th edition, Mr. Alex Asenga, to announce to us the winner of the spirit of the moot for this 10th edition. Mr. Asenga, please.
Yes, good afternoon. As Mr. Martin Kioko said, this being the 10th edition of the All Kenyan Moot Court competition, we had to find a way to appreciate an organizer, somebody who has been there for the last very many editions, because this Moot Court competition is organized by students. Martin is a student, all of us are students, all those who are here before us, they were students. So we always have exceptional students who always come back. Somebody who is always there to assist you in conceptualizing the theme, to assist you in drafting the moot question, to assist you in various sectors. So we saw the need to appreciate one of us. We wish we could appreciate all those who have been instrumental, but in particular, one of us who has always been there. This person was, okay, if I say it, you'll know him. I don't want to say it. Yes, but let me just get done with it. This person was the former president of the All Kenyan Moot Court competition in the 7th edition. Before then, he was a committee member. And since the 7th edition, I think in the 6th edition. Oh God, the 6th edition in 2017, or was it 16? Around 2017 till date. He has never failed to come back here. He has never failed to step in and to step up where we need him. Anytime you need him, anywhere, he will always, always show up. Ladies and gentlemen, please assist me to welcome Mr. Timothy Tondu as the winner of the Spirit of the Moot Award. This award,
he deserves a standing ovation.
This, this award, please allow me to call my entire committee members to join me in appreciating Mr. Timothy Tondu.
Mr. Tondu came to the All Kenyan Moot Court competition in first year and has never left. And we're very grateful for that. Yeah, and he has never left. So we're very grateful to you, Mr. Tondu. So we will just do 2 more things, then we'll proceed for lunch. We have one of our partners who was unfortunately not with us here earlier to speak about the journey that we've had with them. So we'll listen to them, then we'll listen to our president giving the closing remarks, then we'll go for lunch. So please help me in welcoming Mr. Guilford, who represents the Raoul Wallenberg Institute, one of our partners for the 10th edition. Please clap for him.
Thank you very much. Present here, judges, class, and other students, good morning. First, let me start by appreciating this opportunity. And apologies for coming to the closing ceremony a bit late. I was around. I think I was actually in one of the sessions in the morning, but had to leave briefly to attend to an academic network meeting that was happening online. So with him, but I do appreciate the opportunity to make some remarks at this closing. So allow me not to read any speech, but just to make some brief remarks to appreciate the organizers of this event and to express our gratitude and pride in associating with the Kenyatta University and all other universities that are taking part in this and the academic fraternity involved in organization of such events. For us, this is an important event in that the RWA, Raoul Wallenberg Institute for Human Rights and Humanitarian Law, seeks to build a culture for human rights and enhance the promotion and protection of human rights globally. But through the Region Africa program, which Kenyatta University happens to be a member of the academic network, a very active member, and we're proud of. By the way, we actually, I think like was mentioned by my colleague at the opening session, we still are very proud that KU won the Moot Court competitions that happened last year for the African human rights competition. So, and we hope that the spirit keeps on. Of course, we are also happy that other universities go to participate. Such events are important to us because one of the things that we seek to do is to see that the human rights commitments in Africa are implemented, which is a big problem, not just for us, but for everyone else. Our programs are based on the premise that it's not a lack of instruments or frameworks or mechanisms for such, but rather the utilization that makes it not possible for us to implement such commitments as a continent. And that comes down as a country. This theme for this event, this Moot competition is of particular relevance
to our country, Kenya, because we all know what happens during elections. Massive human rights violations, limitations of fundamental freedoms like access to information, etc., etc., and various serious human rights violations, including gender violence, gender-based violence, and in cases where there's been serious violence, like happened in 2007, 2008, many lives are lost and properties are destroyed. And as much as we continue to speak about democracy as a continent and as a country in particular, where we encourage people to participate in such processes, you notice that it can be difficult encouraging people whose rights have been violated constantly in every election, of why they need to be part of such important processes in the country. And so addressing human rights violations becomes an important element of making sure that people have more confidence and trust in the process and are able to engage more meaningfully. And of course, that is not just at the country level, but we also get to meet the targets that are there at the regional level as a continent, which has remained, a big problem. So we would like to express our appreciation as RWA to the organizers of this event. Thank you so much, Dr. Kabata, Asenga, and your team, and everyone else involved in this. We're proud to be associated with such events, and we are happy that it's not just happening at the regional level where we expect Kenyan universities to go take part, but it actually happens in here, because charity begins at home. So that, and more universities and students are able to participate here, even when we may not be able to have many students take part at the regional level. And we also are very proud to see the quality of students. I mean, I was in one of the rooms that was this morning, and the vigor that was displayed and the quality of arguments is very refreshing, you know, to know that our institutions are grooming quality human rights advocates that will help us achieve some of these human rights goals. And with that, I want to say thank you once again, and please continue doing the good work. Thank you very much.
Thank you very much, sir. And we're also grateful for the Royal Wallenberg Institute coming on board, and we hope to partner with you for future editions. I will invite Dr. Faith Kabata again to award Mr. Guilford on behalf of the Royal Wallenberg Institute. Please clap for them. Thank you very much once again. And now to come to the close of this ceremony, I will invite the president of the All Kenyan Moot Court competition for the 10th edition, Mr. Alex Asenga, to take us through this 10-year journey and also to prepare us for the anniversary celebrations, which will be coming immediately thereafter. So please clap for Mr. Alex Asenga Gidara. Please clap for him once again.
Well, thank you so much. Thank you so much. I actually forgot I was to do a speech. Yes, but I am here, and mine will just be to reflect upon this competition, the 10th edition, and to reflect upon the previous 9 years. Now this is the 10th year. And I can say that when I first took office personally, and I was told that you are the president of the 10th edition, I imagined all the rest that have gone before me, Akina Timo, they're here, all those great people before me. And then I was the one now coming for the 10th edition. Honestly, I felt small. I felt small. And then they tell you that yours is the biggest of all, the 10th year. Then, you know, you have to sit down. I remember my very good friend there and former AKMCC committee member, Njoki. Njoki, please stand up. Please, let's give him a round of applause. Njoki is also one of the few people who, I mean, anytime, anywhere, Njoki would even have calls at 2 a.m. Njoki would call me out of the blues. Asenga, how is AKMCC at 2 a.m.? And I mean, I always thanked him for that because, I mean, he would always try to find solutions. He would always check up, what do we do next? And that's something which, I mean, I don't take it for granted, Njoki. My committee and I are so much grateful and we are treasured to have you. AKMCC is treasured to have you. So when I took office and I was told that it's the 10th edition, I realized that I had a big task ahead, a very big task ahead. And for the first time in the last 3 years, we are coming back to a physical competition. And that would mean, you know, coordinating all law schools coming here, coordinating accommodation, coordinating catering, all these which are very, very heavy, very, very heavy items on a budget. And mine is just also to thank, first of all, I always call her the ex-officio committee member, and that is Dr. Faith Kabata. Daktari, we as the AKMCC committee, we as the students of Kenyatta University School of Law, we are so much humbled and honored to have you on our side. And thank you so, so much for the invaluable work you've put in this committee. We don't take it for granted. Thank you so much. Then I'd also like to thank my very able committee members. Please, committee members, could you kindly stand up? That is part of my very able committee members. Just close here. Christine, you can wave your hand. This is Christine. She's the conference director in charge of all conference materials and all conference ideas, all these things you're seeing, the arrangement. She's the one who is in charge. And then next to Christine, we have Miss Michelle Kakai. Kindly wave. Michelle Kakai is the deputy moot court coordinator. She serves under Miss Janet, who I shall come to. Michelle has been very, very instrumental. Whenever called upon, she always chips in. Then next to her, we have Mr. Kimani Njenga. Mr. Kimani also serves as the deputy communications under Milton Duro. All those posts, all those posters you're seeing, Mr. Kimani is the one who has been in charge. Thank you so much, sir. And then next to Mr. Kimani, I have my very, very able deputy president. That is Mr. John Mwasa. Kindly wave. Mr. Mwasa has served as my deputy president for the 10th edition. Thank you so much for your support. Thank you so much for your invaluable contribution. The committee and I personally don't take it for granted. Asante sana. Then next to that, we have a very hardworking, albeit short lady. Could you please raise your hand? That is Miss Janet Karimi. She is our moot court coordinator. Janet, thank you so much for organizing the moot. Actually, I didn't even have to worry about the moot. You didn't see me running around in the moot courts. Janet was always there, and she's very, very capable. Thank you so much, Janet. Next to Janet, we have Miss Susan Maina. Miss Susan Maina served as the communication, as the secretary of the committee. All those wonderful emails you are seeing, all those communications, Susan was always in charge. Thank you so much, Susan. Asante sana. Next to Susan, we have Milton Duro. Milton Duro was or rather is still, the communications director in charge of communications for the All Kenyan Moot Court Committee. He is one of the few members who have been here from his first year. He has dedicated his entire 4 years to serve in the All Kenyan Moot Court competition. Thank you so, so much, Mr. Milton. Next to Mr. Milton, we have Mr. Daniel Murakaru. Mr. Daniel was the head of the research category. I had the honor of training Mr. Daniel before he got in the committee. He's a very, very wonderful gentleman. Daniel, keep it up. Keep it up, and we hope to see that this competition goes on and on and on. All right? Thank you so much. Next to that, we have a very wonderful lady, Miss Michelle Deborah. All right, I know you all know her because she's the one who brought in the cake, but actually, in the committee, she served alongside Christine in the conference docket. They've done a wonderful and amazing job, amazing duo. So thank you so much, Michelle. Thank you so much for that. Then next we have our finance director in terms of money, yes? Her name is Viola Nyaboke. Also, she has also been with us from her first year. All those 4 years of service. Let's please give her a wonderful. Ms. Viola is in charge of our finances. So anything to do with money for the committee and accounting purposes, she's the one in charge. Thank you so much for that, Ms. Viola. Then lastly, we have our very own students coordinator. The students coordinator, his name is Martin Kioko, and he has been very, very instrumental to the committee. Even despite being the committee, even to me as a person, he's been my wonderful person. He's been close to me. Yes, because I would tell you, sometimes being the president, you have to make very quick decisions, very instantaneous decisions, and they're very heavy decisions. So I always know that when I call upon Martin and my entire team, guys, we have this thing to make a decision onto. They always deliver. They always deliver. And that's why here today, we have the 10th edition courtesy of that team. So let's please give them a round of applause. Thank you so much. You may have your seats. Thank you, Sante Sana. And also, this event would not have been possible were it not for our very able bailiffs and rapporteurs. Bailiffs and rapporteurs, kindly please rise up. Let's please give them a hand of applause. So this team here, our bailiffs and rapporteurs, they were in charge of general coordination of the event. They were in charge of directions, in charge of registrations, in charge of allocations. They are the best team I've worked with so far. Please, let's give them another round of applause. Thank you. You may have your seat. Now, I'd want this to be very short. First of all, I just start by, when you are thinking about this 10th edition and the theme it would fly under, we couldn't agree on anything less than elections, because we are nearing towards an election period. And we saw the need of the youth to engage in election matters, in trying to find solutions around electoral problems, in trying to find solutions around electoral practices, in trying to sensitize the youth to go out there and spread a message of peace, a message of hope, a message that we as Kenya is and can be a democratic country, that we can hold free and fair elections. And that is why we came up with this theme, electoral justice and democracy, ensuring electoral credibility and adherence to the rule of law. So I thank all of those who helped us conceptualize this theme. My many thanks would go to our partners who supported us in not only coming up with the theme, but in also drafting the moot question, drafting the research questions, technical advice. And one person I should mention is Miss Isabella. Miss Isabella, thank you so much. Isabella here, she helped come up with the moot question. She was part of the very early drafters of the moot question. Asante sana. And I thank all the wonderful partners, not forgetting Professor Mwimali. Professor Mwimali, who is the CEO of Kenya Law. Professor Mwimali, he drafted the research question. He was the one who drafted the research question. Prof, thank you so much. We are humble and grateful. And to our very, very able, more than 19 partners, we thank you so much for the wonderful support you've allocated us in terms of finances, in terms of technical support by giving us judges, in terms of organizing, and also in kind. We are so much grateful. Bringing together 19 partners is not an easy feat, and we thank all of them for taking their time, for taking their expertise out, just out of their busy schedule to come and be with us here today. We as the All Kenyan Moot Committee, we are so much grateful. We thank all of you. In particular, I'd like to thank the Council of Legal Education, Mzalendo Trust, RWI, and FNF, our new partners for this edition. We are very much grateful for the support you've afforded us, and we look forward to support in the 11th edition, in the 12th edition, and in the coming many editions. We don't take it for granted, and we are so much grateful. Thank you so much, Lillian, on behalf of FNF. Thank you so much, Mr. Guilford, on behalf of RWI. Asante sana. With that said, I'd like to talk about the impact of the moot. I remember when we went to Mohammed Mugai to seek for partnership, and we sat there. I was with Mr. Martin Kioko. It was on a Thursday morning, I can remember. And we went and sat there hoping to see Professor Gidu Mugai. And the person who received us was, he was a judge here yesterday. His name was Mr. Nkaricha. Mr. Nkaricha sat there and told us, so you're from AKMCC. He came with a team of 4 people. You're from AKMCC. And the way his look was, I had to ask him, why that look, sir? You seem as if you're unsure of something or you want to say something. Why? And trust me, of all those partners we met, 3 of them have participated in the All Kenyan Moot Court competition. I was surprised myself. From the very early 1st edition, 2nd edition, 3rd edition, they participated in it. So mine is just to speak on the impact of the moot. Now, reflecting back, I see all those amazing people who are where they are, including the very late Cindy Wakio, who participated, and unfortunately she left us, a student from Strathmore. Looking back at all those who participated in the moot and where they are right now, honestly, I am so much full of joy. My heart is full of joy. On behalf of the 10 editions, I have seen the impact of this moot. And for me, this moot it's not more than a moot, as I said in the opening ceremony. This moot opens up your ideas to what is this issue you're talking about? Because we speak about contemporary issues. We try to find solutions, and the research papers you've written, they will get published. And all those resolutions you've given, we will always table them. We have Mzalendo Trust here. They were interested because they say that we want to look at the solutions that the young people would give, and we table them before Parliament. We're excited because these research papers would get published, because we are trying to find solutions to these electoral practices. And that's the whole idea behind AKMCC. It's not just a moot. We are trying to find solutions. And with that, I'm also thankful to some of our partners for awarding us internships as well as volunteer opportunities. We heard from Mr. Ochiel Dudley. He graciously stated that we would, or rather Katiba Institute would be able to take in volunteers. And we are so much grateful for that. Thank you so much. And also some of our partners, Mohammed Mugai will be taking in the best researcher. And also Kaplan and Stratton will be taking in the best team for our 1-month internship. Please let's give them a round of applause. I really don't have much to say, mostly because I'm salivating on this cake before me. But otherwise, apart from that, mine is just to thank every single one of you, all the participants for finding time to attend. And remember, there is never wins and losses in this competition. Never. Because out of this, you have been able to, your mind has been tweaked to try and find solutions to these problems. So please don't stop here. If you've been a researcher, continue writing those papers. If you are a mooter, continue advocating for electoral justice, continue advocating for justice, continue advocating for human rights, continue advocating for spreading peace. Because at the end of the day, I always say that this moot is here for us to create the future. It's here for us to build the future, okay? So mine is just to thank you so much. All the judges that have attended, thank you so much. All the partners who have come here, thank you very much. And lastly, to our host, Kenyatta University, thank you very much for being our host for the last 10 years. We are so much grateful. I don't have much to say because I mean, this cake needs to get done with. So thank you so much. And it's been a pleasure being here. This is not the part where I cry, but thank you so much.
Thank you very much. Please clap for Mr. Asenga. He's been the best president. Thank you very much, Mr. Asenga, for being the best president. And we hope that we will leave the organizing committee to the best of hands. So we now proceed to the cake cutting ceremony, which will be the first part of the celebrations. We'll get some drinks, then we'll go for lunch. So I will invite representatives from our partners. I know we are many of us to step down here so that we take a photo, and Dr. Kabata will be helping us to cut the cake together with Mr. Asenga on behalf of the students. So let's kindly, please clap for them as they come down to cut cake.